Our demand's at 145 and your current offer is 95.
Yes.
All right.
Call may be recorded for quality assurance.
Yeah, you guys always have the longest numbers ever.
We just like to make sure that you really want to talk about it. That's all.
Yeah, and the 17 zeros that are jammed in the claim number too.
Well, it used to not be like that.
Gosh.
Okay, so you were able to talk to the client, or...
Yeah, I was able to talk to the attorney. He's spoken to the client already, you know, so we know where they're at with everything.
Mm-hmm.
Let me just run this one down again, and then we'll go at it with you have our demands at 145 and your current offer is 95.
Yes.
All right, so I have your insured at the time. She was a 17-year-old girl. She ran a red light. We had about $276,000 in medical bills that were charged, but because of health insurance, we were down to just under $42,000 in medical bills. ER, the ortho, MRIs, chiro, and then as we've discussed already with the MRIs, we have her previous accident on 5/22, and then we have this accident on June 30th, and we're showing that one of the herniations is 5 millimeters larger than it was before, and the other one is 3 millimeters meters bigger than it was before, and then there's a tear. I know that you said that you're expert.
He is stating that, you know, again, based on the accident, didn't cause the surgery to be, again, in question here, or worsened, or exacerbated, or made worse. That's what the expert is stating.
I got you. Yeah.
I can really go off and, you know, and summarize. I'm not the expert myself, so.
No, yeah, all good. I know. So he understands though that although the surgery was recommended before this car accident happened, he knows that the MRIs show that the injuries were more significant, and then the orthopedic surgeon put on the records that it would be a more extensive surgical procedure with greater risk, greater costs, more rehab involved, and then you don't even know the recovery percentage either, you know, when you deal with a more extensive surgery. He's not including that in his evaluation. He just doesn't see that as something. So he's disagreeing with the orthopedic surgeon.
Correct. And
Got it.
Our expert is an ortho, yeah.
So your expert is an orthopedic surgeon as well.
Right. So we basically have dueling experts.
We're aware that your insured also goes to school in upstate New York, and I hardly doubt that her parents, and I don't know if you guys even care, but I'm sure that her parents called you up and said, look, you guys need to settle this case. We do not want to have our daughter fly from upstate New York back down to Texas in the middle of her going for her degree, which would happen if we have to file suit here.
Bear with me a moment.
Okay.
Going back to liability real quick. I just wanted to point that out, that it's not a huge impact based on the property damage photographs and then the amount of those through the intersection. So liability and damage there is something that we don't want to get away from when we're talking about the injury sustained and the treatment she got, right? I think that's important. You guys obviously make a point of bringing up attention to severity of impact in your cases, and I just wanted to make sure that we're both reminded of and back on the same page about that for this, right?
I gotcha. You know, in regards to the property damage, I know that it's an older vehicle too, so, you know, the vehicles are made a little bit differently back then. You know, people like to say that they were actually more durable back then. So to have the impact even on a more durable vehicle like this, to us, $4,000 is still enough damage to consider an injury. I mean, either way, property damage is an unfounded causation in Texas anyway. When it comes to, I know juries are still going to look at photos and people are still going to decide those things, but legally, you know, you can't say, well, there's less property damage, so there's less injuries once we get that far. Just real quick though, too, on the accident report, it's very common for officers not to just, they'll put someone at fault, but then they won't give a ticket if it's one of those, this was kind of things. But they still gave her a ticket because they clearly saw her, even as a young girl too. Like, officers, oh, it's a young girl, she was barely made it through. They're not going to give her a ticket, but for whatever reason, this officer felt, I don't know, to give her a ticket. So maybe it was a little bit worse than we know. Neither one of us were there.
But I hear everything else. I want to resolve the case. I really do. I don't see it at 135, and I know that's where you're saying where you're at. I want to make a move to resolve it. I want to move to 115. And I moved there hesitantly because of everything we discussed and reiterated today about the damages and the pre-existing injuries and all that kind of stuff. So
we're $20,000 away at this point.
we are. We're very close. I hope we can resolve it.
I hate to use the phrase, oh, why don't you just split the difference to me? Because it's not always like that. It's not always, oh, let's just split the difference and then call it a day. It's like something that has to be said in every negotiation. You have to say split the difference at least one time. But
it's almost like you get it's like a drinking game. As soon as someone says split the difference,
yeah. I could have made so many different things off that. Never mind. It's just, one split the difference, you're over the legal limit, and then, and never mind. That's all it takes. That's all it takes. But in this situation, if we could do it, I'm good with it.
Okay.
So that'd be 125.
125?
Yep. That's got to be it, Sean. I can't go. I can't.
I hear you. Okay, let's do that.
Okay.
125.
125. Sounds good. It's a deal.